is a part heard in the matter of Morais and others in Ryanair DAC.
Yes, good morning, Will. Morning, mate. I put my metaphorical running shoes on this morning, but I'm conscious of the fact that that can sometimes mean that one takes things at too quick a pace. Obviously,
we'll say
guided by your lordships, and my lady, if that proves to be the case. Can I just recap as to where we got to yesterday? We looked at the initial consultation papers, and I say we identified the mischief, and the mischief was not confined to union membership. There was something more concerning that Parliament was seeking to address, and that was particularly apparent after the TCA, Consulting Association raid, which revealed the presence of union activists or troublemakers whose employment prospects were blighted by having been included on that list. And the union activities or the union activists on the list were not ones who'd simply taken part in the day-to-day union activities at an appropriate time. They were ones who had participated in industrial action. And of course, it's just that sort of thing that gets you the label troublemaker. You don't get labelled a troublemaker because you go along to the lunchtime meeting in the boss's time. You get labelled a troublemaker because you're on the picket line seeking to persuade your colleagues not to go to work and causing damage to the employer's business in pursuit of your industrial or collective aims. The second point we say is derived from the first look at the consultation papers is that the debate was not about whether industrial action was in or out per se. It was about the limits of that industrial action and whether it should extend beyond union-sanctioned industrial action and into what's commonly known as wildcat action, which is a particularly militant form of industrial action that doesn't have any union blessing attached to it. And there's no suggestion in any of the consultation papers that we've looked at so far that Parliament wanted to create a regime that was circumscribed by reference to Part 5 or more particularly Section 219 immunity. The particular concern was in any event not dismissal for taking part in trade union activities. It's a slightly different issue. It was, what is it that gets you onto a blacklist? What are the activities? What are the sort of things that union activists are doing that get themselves onto a blacklist? And that was what was of concern to the legislators. It was to circumscribe the activity of identifying people as troublemakers, in part because they had taken part in industrial action, creating a list, and then using that list, in the case of the construction industry in particular, to blight the employment prospects of those who appeared on it. And the last point that I made yesterday, before taking the debate forward this morning, is that on Mr. Gott's construction, on Ryanair's construction, it would mean not only that the particular mischief had not been addressed, but in fact the opposite will have been achieved, because a green light will have been given to employers that it is fine to compile a list of union activists if they have taken part in industrial action. That would be a blacklist that was permissible, that could then be circulated across the industry. So, mischief not achieved, but worse than that, a reverse effect. You come out of the parliamentary process as a trade union activist in a worse position than when you went into it, because the process of blacklisting would have been sanctioned as long as it was related to industrial action. And that cannot be right as a matter of common sense or construction.
Why does it make matters worse?
Oh, because the signal will have been sent that this is all fine. Up until that point, Parliament hadn't addressed it. But by implication, when addressing it, they will have approved the process of compilation of a list based on trade union activity in the form of industrial action. That's why it's worse. It is that express or implied signal from Parliament that blacklisting is fine as long as you confine it to those who've taken part in strikes or other industrial action. And in the light of the intended mischief, that cannot have been the intention of Parliament to achieve that result. So if we then go on to the next phase in the consultation process, which was to where the government sought to consider and take account of the various responses to consultation that came in after the initial consultation document was set out. If one goes to the authorities bundle at tab 35, page 873, one finds the government response to consultation set out first of all in the executive summary at page 877. And it's interesting to note, and I had a cheap shot yesterday when I noted that Eversheds were one of the consultees, but it's interesting to note that when one looks at the employer's response, as set out at the second paragraph on page 877, they generally supported the case for blacklisting without any apparent reservation on the basis of excluding industrial action from the scope of the blacklisting regulations. Um, 879, not terribly important, but just for your note, they flagged up, the government flagged up that the guidance, which we'll look at in a moment, would come along in due course. That's the last paragraph on 879. Then at 885, well, I think perhaps another interesting historical footnote before we get to 885 is at 883, where you'll see that, ironically, given that the catalyst for legislation in relation to blacklisting came as a result of what went on in the construction industry, you'll see that the employers' organisation, the Federation of Master Builders, paragraph 2.6, strongly supported the government's proposal, and they, along with other employers' organisations such as the CBI, CECA and AMEC, stated their opposition to the blacklisting of trade unionists. So everybody's on the same side here. Everybody is proceeding on the basis that blacklisting of trade union activists is a bad thing and needs to be prohibited, and consequential sanctions to be provided if blacklisting takes place and is then used to the disadvantage of those who appear on it. At 885, a reminder of the government's position on this, 2.9, the government reiterates its views shared by virtually all respondents that the blacklisting of trade unionists is a reprehensible activity. And that's important, again, because if the regulations in Section 3 are to be construed so as to allow the blacklisting of those who have taken part in industrial action, that sits very uncomfortably alongside the strong language used by the government in showing its opprobrium towards this practice, reprehensible. Of course, on Mr. Gott's construction, it's not reprehensible, and indeed it's a perfectly legitimate activity to list those who've taken part in industrial action. And then at 892, important section that deals with the definition of trade union activities, and I suggest that this is significant and important because it's further evidence of where the debate was in relation to industrial action. It was never a question of whether or not industrial action would be included or excluded. It was a different question as to, once you've included industrial action, what is the scope of that action that is to be caught by the regulations that were introduced. And you'll see at paragraph 3.19 on page 892 that perhaps uncharacteristically, no, other way around, perhaps in accordance with the approach you might expect from them, Thompson sought to push the envelope so as to cover all forms of industrial action, whether or not there was a union involvement in that process. And UCAT and the TUC, in similar vein, sought to push the regulations to cover any activities associated with trade unions in the hope that this would catch all forms of industrial action, whether union sanctioned or not. And the government's response to that was that the trade union proposals, which we can see addressed at page 893, paragraph 3.23, was that to do that would run the risk of extending the prohibition beyond the vires provided by Section 3. So government, we say quite rightly, expressing the view that if you sought to extend the definition of industrial action to include unofficial wildcat action, that would create a vires problem, given the limits of the delegating power contained within Section 3 of the 93 Act. And then the paragraph, as we're on this page, or as we're on this part of the authorities bundle, I'm going to ask you please to look at page 894, page 3.24, because what I'm going to do in a few moments is come to identify the differences in the language and context as between Section 146 of the 1992 Act and Section 3 of the 1999 Act and the regulations. Because if you look at 3.24, you will see that it records the government does not accept the union proposal to limit the protection to just the members of independent trade unions. And we'll see, and it's probably in your minds already, that the provisions of Section 3 do not include the word independent. And the reason why that's important is it's yet another indicator that the blacklisting provision in Section 3 and the regulations that came 10 years later was doing something different and was addressing a different problem to Section 146. And the omission of the reference to independent means that protection is given under the regulations to a group of people who can never come within Section 146. So members of a trade union that is not independent, so most obviously a staff association, are protected by the regulations because they're members of a trade union, albeit not an independent one, whereas 146 is limited to those who are members of independent trade unions. And that's a further clue to the wider context in which Parliament was addressing the problem of blacklisting. It wasn't blacklisting confined to members of independent trade unions. It was the potential for blacklisting to extend to members of trade unions which were not independent.
Well, it goes to your core point, doesn't it, that there was a specific purpose behind these regulations to address a particular mischief.
Correct, yes. And the other reason why this is important, and the omission of the words independent is important, is that when you come to look at the wording of Section 146 and the wording of Section 3, they're plainly doing a different job in different statutory contexts. And so slavishly following the rule that the same words must mean the same in different statutory contexts, in the same statutory context in a different statute, ignores the fact that the context is entirely different. So I don't seek to attack, as it were, the suggestion that as a general proposition, the same words in a similar context in a different statute will fall to be construed in the same way as they had been considered in an earlier statute. But that ignores the difference in language and the difference in context. And there are multiple differences in language, which I'll come to in a moment. But I took you to this one because it's a convenient moment, because we've got that document open, and we're looking at page 895, which is immediately adjacent to 894, which is the one I just took you to. There's then a debate at 327 to 328 about trade union activities, the government's response to the Thompson's TUC UCAT suggestion, we can see dealt with at the end of 327. The wording suggested by certain trade unions designed to include any union involvement in the organisation and the taking of unofficial industrial action. Government believes such industrial action is especially disruptive and injurious to orderly industrial relations, because by definition the trade union has not endorsed or controlled it. So that's the statutory debate, that's the consultation debate that then leads to the regulations being formulated in the way that they are, with the government repeating its view that trade union activities almost certainly covers involvement in official industrial action. And Mr. Gott, we say, can take no comfort from the fact that it uses the language of almost certainly rather than does, quite properly and sensibly in a consultation document. The position is hedged around the possibility that there may be some form of official industrial action which might not be appropriately covered by the regulations, hence the use of the slightly caveated language of almost certainly covers. But that's good enough for me, I say, because again it's illustrative of the debate being not about the inclusion of industrial action within the scope of the regulations, and we say also the Act. It's a debate about how far you take that inclusion. And the government then took the view that no definition would be introduced. Again, within the same document, at page 907, so that we don't have to come back to it when I'm dealing with point 2, you'll recall that yesterday afternoon I made a reference to time limits, and I know Lord Justice Bean will be familiar with the time limit regime in employment tribunals. Whether your Lordship and your Ladyship are as familiar, I don't know. But for your vanilla unfair dismissal case, there's a 3-month time limit subject to the limits of reasonable practicability. So if it wasn't reasonably practicable to get your claim in within 3 months, then that was your only escape route from the rigidity of the 3-month time limit. Now, in discrimination legislation, there's a rather easier hurdle for a claimant to overcome, because in discrimination legislation, the time limit test is whether or not it's just and equitable to extend time. So one of the many quirks of employment law is that depending on the type of claim you bring, the time limit regime will be subtly but significantly different. Reasonable practicability is generally a higher threshold to get over. Just and equitable gives you the ability to take into account wider circumstances relating to the claim. And the pushback that came through the consultation process was that reasonable practicability was too high a threshold for time limits in relation to blacklisting claims, because it might be many years before anything came out. The action may have taken even longer than that. And so the government moved the goalposts in favour of claimants to make time limits easier for them to get over. And you'll see on page 907 at 3.63, it refers to the reasonably practicable test that I've outlined, and then says the government recognises blacklist existence may be discovered many years after it was first established and used to discriminate against trade unionist employment, therefore wishes to ensure that tribunals use their discretion to extend time for bringing claims where blacklists have been concealed. And the reason why that's important is really in relation to ground 2, because under ground 2, Mr. Gott says that many years after the event, the tribunal should be examining possibly a different employer's strike action to see whether the provisions of section 219 had been complied with. And the practicalities of Mr. Gott's ground 2 argument fly in the face of the difficulties which the government had acknowledged at 3.63. And I'll develop that submission in due course when I'm on to ground 2. But again, for convenience, because we had this document open, I thought it might be helpful to have a look at it. The other feature that one gets from this document appears at page 913. Where the government addressed a point made by respondents to the consultation process that the draft regulations did not have sufficient deterrent effect. This is paragraph 3.78. And it makes what we suggest is quite an important point, where it says that the government recognises that, other things being equal, individuals would receive exactly the same form of compensation for being refused employment for trade union reasons, whether the employer had or had not used a blacklist. But because of its significant distaste for the practice of blacklisting, the government took the view that there should be an additional penalty which exists in the context of a Regulation 9 blacklisting claim, but does not exist in the context of a Section 146 claim, which is a minimum level of compensation of £5,000. And that is yet another indication that the blacklisting regulations are looking at a different problem and providing a different solution to that which is covered by Section 146.
That finds its way into Regulation 12.
I believe it's Regulation 12.
Does it not? Which we have.
11.5.
11.5, thank you.
11, sorry. Regulation 11. And we looked at this briefly yesterday, but just to understand how Regulation 11, page 171, works.
Yes.
Does it go like this, that the tribunal's power to make an award is discretionary, in that it is not required to make an award, but if it does?
Yes, because the introductory words, so working through Regulation 11, we can see that there is an element of discretion in that under 11.1 it shall make a declaration and may make an award of compensation.
Yes.
And then at 11.2, subject to the following paragraphs, the level of compensation, so the compensation is just and equitable, where it does get to the position of making an award, that award is not less than £5,000. And you don't see a parallel to that contained within Section 146. And if one looks at the remedies section for section 146 claims, there are some similarities in that it shall make a declaration. This is page 28 of the authorities bundle, where it finds a complaint to welfare. It shall make a declaration, may make an award. And again, the test is just and equitable.
So the first thing that the tribunal has got to consider, having found that there has been a breach, is whether it would be appropriate to make a monetary compensation
Correct.
award.
Correct.
And that's a yes or a no.
Yes, because there may be circumstances in which it's not appropriate to make any form of award because the breach was minimal or the consequential loss was de minimis or non-existent.
Having decided that it should make an award, could you just, I'm sure it's perfectly clear, but while we have your help, it says it's not to be less than £5,000 and is to take account of the matters in sub 3, to be reduced because of the merits of the claimant and contributions made by the claimant and so forth. Does that fit exactly with the guidance, the response that you've been showing us a moment ago, namely that it can't go below 5,000? I mean, are we to treat £5,000 as being a starting point, or is it?
No,
it's a floor.
Yeah, it's yeah, it's a starting point because once you get through the door of an entitlement to compensation on the tribunal's analysis, your starting point is 5,000. No, sorry, I'm wrong about that, because the introductory words of 11.5 allow for the possibility of an increase or a reduction. So it says where an award of compensation is made, the amount of compensation before any increase or reduction, and one can see within 6, 7 and 8
things that might
cause a reduction to be made, not least if you've at the same time been awarded compensation under section 149 as a result of the section 146.
5,000 is a starting point.
5,000 is a starting point, yes.
Right, so that's where the discussion begins. If you decide, unless you've decided that you're not considering making any monetary compensation at all.
Yes, and that would fall to be reduced, and I'm not sure how it would actually work in practice, but there is at least a theoretical possibility that the conduct of the complainant warrants a just and equitable reduction under 11.6.
Yes.
And of course, it's a glimpse of the obvious, perhaps, but it becomes very apparent when you look at these provisions, but it's also apparent from all the other provisions, that the scope of the potential claimant is much wider than section 146, which is why one sees the claimant described as P. So you can be a victim of blacklisting as a result of things done by people other than your employer. So, for example, you can bring claims against employment agencies.
Yes.
So there's a wider category of potential respondent to that which exists under section 146.
But would it be right for us to take away the fact that sub-paragraph 8 is in many ways the most important for the moment for your argument, namely that it would tend to suggest that these are distinct remedies?
Correct.
It's just that they don't want to have double recovery.
Correct, yes. So it acknowledges the potential for a claimant to succeed on two bases. One, he or she could get an award under Section 149 as a result of a breach of Section 146, but at the same time could also bring a blacklisting claim if a list had been prepared which is a prohibited list and the reason for dismissal related to your appearance on that list.
Before leaving this, if £5,000 is the starting point, and there are various things in 6 to 7 which could reduce it, as well as the subparagraph 8, no double counting rule, you're not going to be reducing those amounts very much simply because it wasn't the worst sort of blacklisting that you can imagine.
No, blacklisting is a bad thing.
It's a bad thing unless on looking at this one might think that it was so untroubling that you shouldn't be thinking of compensation at all. But once you get into the compensation regime, you start at 5,000, and
yes,
apart from it only as described.
Just a quick illustration of how that might work in practice. If the tribunal formed a prima facie view that you'd lost £2,000, let's say, as a result of a blacklisting dismissal, if that was also a Section 146 claim, your starting point would be £2,000, and if there was then a 50% deduction because in some way you'd contributed to that, then you'd end up with £1,000. But if you had a blacklisting claim and you started with £5,000 as your threshold figure, reduced by 50% to mark out your contributory fold, that would take you down to 2,500. So it just shows that there is something that the government is particularly concerned about in relation to blacklisting, which warrants the introduction of this starting point for compensation under Regulation 9, that doesn't exist in relation to Section 146.
Thank you.
So what you've got two distinct lines. You do one assessment, let's for the sake of argument, Section 146. You do another assessment for the purposes of blacklisting. And then you stand back and look at the totality. And if required, adjust accordingly.
Well, it requires adjustment so that you don't get double
Precisely
recovery
that.
under Section under Regulation 11.8. And I suppose it could be said that although we lost on because of Mercer on our 146 claim, but the very facts of this claim gave rise to a 146 claim, which once the legislation is changed in order to address the declaration of incompatibility made in Mercer, we would be able to bring a 146 and a blacklisting claim at the same time because they're addressing different vices. 146 addresses the vice of dismissal for an illegitimate reason. The blacklisting regulation addresses the vice of creation of a prohibited list and the use of that list in order to subject individuals to detriment.
When you said dismissal, you meant detriment?
I did mean detriment, yeah. Although the same analysis would apply to a dismissal case. The final point that I wanted to make with regard to the consultation document is at paragraph 3.102, page 920 in the Authorities Bundle, Volume 2. And that is this, that the government had the power but did not use it to amend Section 3 itself. And so had it been the view that Section 3 in some way was inconsistent with the regulations in that it excluded industrial action from the framework of activities of a trade union, we would suggest that the government would have used the power that it had under Section 3, but it took the view that that was unnecessary. And we say they were right to take that view because there is no inconsistency between the construction of activities within Section 3 and the construction of activities within the regulations. So, again, whilst we've got the authorities bundle open, if I could ask you to turn to the next tab, and I think we've probably covered this in Mr. Gott's submissions, but for my note, it's 932. Again, a reiteration of the position post-introduction of the regulations, alongside the BIS guidance, that official industrial action would probably be categorised as relevant activity. So when you look at the regulations themselves, construed in the light of the mischief which they were aimed to address, in the absence of any definition of trade union activities and the absence of any reference to appropriate time, we say that taking part in the activities of trade unions should be construed in the regulations so as to include industrial action, and we say that that position is maintained when you go back from the regulations to Section 3 of the Act. And we say, had the intention been to exclude industrial action from the scope of the regulations, Parliament would have made that clear. They would have, for example, gone with appropriate time, in the full knowledge that the effect of including appropriate time was really to exclude industrial action from the scope of the definition. And that, I'm not sure how far Mr. Gott challenges this, but we say once you've got to the untrammeled language of activities of trade unions within the regulations, you apply the normal appropriate definition of those words, as to which there are at least 5 occasions on which tribunals and courts relevant to today have said that as a matter of normal language, industrial action is included within the scope of trade union activity. It's what, and I'll just give you the references, it's what the tribunal said, see page C163. It's what the EAT said, see page Core Bundle 125, sorry, ET was Core Bundle 163, EAT Core Bundle 125, paragraph 85. It's what has been said throughout the passage of Mercer through the courts, EAT paragraph 27, page 594 of the authorities bundle.
Just slow down a bit. Mercer, EAT.
Paragraph 27, page 594 of the authorities bundle. Mercer Court of Appeal, paragraph 51, page 706 of the authorities bundle. Mercer Supreme Court, paragraph 44, page A732 of the authorities bundle. And the other important feature which I'd like to flag up now flows from what was said in Mercer about blacklisting. Because if I can take you please to Lady Simler's judgment there's an important presumption that emerges from a discussion that's had about submissions that Mr. Stillitz made on behalf of the Secretary of State, which begin at paragraph 84 on page 745. And although it's in the context of a discussion about Article 11 rights and whether or not a fair balance has been struck, nevertheless, the premise on which that discussion takes place is, we say, of relevance to the deliberations that this court will make in due course. Because one can see at paragraph 84 that the submission made by Mr. Stillitz was that, well, a fair balance had been struck because there were other remedies available in respect of trade union activity, which meant that you didn't have to construe section 146 in such a way as to indicate that the Article 11 rights of Miss Mercer and others had been offended. And Mr. Stillitz, in that context, was saying to the court at just about letter D on paragraph 84 that one of the protections that existed in respect of industrial action was the Blacklisting Regulations. So he refers to other protections in TULRCA and the Employment Relations Act 1999 and the Blacklisting Regulations. The response from Lady Simler was that she was not persuaded that these gave real or effective protection in the case of a striking worker. And the reason why the Blacklisting Regulations did not provide effective protection in the case of a striking worker was not because striking workers sat outside the scope of the regulations, but was because it only applied where an employer created a prohibited list. So the assumption that is made by Lady Simler is that, yes, striking workers are included within the regulations, but that does not discharge the state's obligations under Article 11 because it only applies where a prohibited list is created. So she proceeds, and the whole of that debate proceeds on the basis that strikes are included within the scope of the regulations.
Well, that was Mr. Stilitz's submission in that case, and he's about to make it in this case as well.
I hope he is.
Let's see. Is the reference to the Blacklisting Regs at 842G submission of Mr. Ford, which Lady Simler accepted?
What immediately precedes that is Mr. Ford talking about the implied term of trust and confidence, and saying that that doesn't give the employee a remedy in respect of strike action. I'm not sure that it records the submission that he made, if he did make one, directly by reference to the Blacklisting Regulations. Certainly my reading of that preceding sentence, it was looking at a different point, because Mr. Stillitz was putting forward a range of options under which there was protection in respect of striking employees, including the implied term of trust and confidence.
I don't recall that the Blacklisting Regs were referred to at all in the Court of Appeal, but if they were, then Somebody will tell me.
Well, there are people on this bench who were present and myself not included. So I'm going to duck that one and leave it to others.
But those are the only references in Mercer on the two on this page.
I believe so, but I do stand to be corrected. The reason that we latched onto these was, of course, it supports the argument that I put forward, that the premise of the discussion in the Supreme Court was one based on the inclusion of strike action within the scope of the regulations. So we reach a point, we say, where the regulations are clear on their face and plainly on a proper construction against Mr. Gott. And the next question that I was going to put to the court was this: does that analysis change when you trace back from the regulations to the statute? So, putting it a different way, does the statutory wording mean anything different to the wording in the regulations? And Mr. Gott's short point is, we say, can be summarised as follows. Section 152 does not include industrial action, see Drew and Mercer. Therefore, neither does section 146, because it is a sibling provision. And therefore, neither does section 3 of the Employment Relations Act. And whilst we don't take issue with the first two of those propositions, we do take issue with the third proposition, which is that you have to construe section 3 based on the authorities that were the authorities that deal with section 146 and 152. And we say that is wrong for a number of reasons. The first one is that whilst we accept as a general proposition, and it's a point that I've already touched on this morning, but I'll just repeat it briefly. The first one is that whilst we accept as a general proposition that where language appears in similar context, in similar form in different statutes, the court will start from the position that it means the same across the two statutes. But there are limits to that.
We were shown a remark of somebody, was it Lady Simbler, yesterday, that rule is not invariable.
Well, I was going to make that point by reference to the extract from Crace that Mr. Brittenden, who's running shoes that work better than mine, will identify if that's to be found in Lady Simbler's judgment. But I was going to make a similar point in any event based on the extract that you find at the back of volume 2 of the authorities bundle. Page 942 behind tab 38. And one can see that the language is rather less rigid than perhaps Mr. Gott would like it to be, because just looking at the second sentence at the top of page 942, the obligation is that the courts will have regard to the previous construction, and indeed the extract that one then sees from Re-Debtor number 784 of 1991, which is the Hoffman extract that one then sees indented, long-established principle, that where it appeared, where the same word or phrase appears in a similar context, it must be construed so it's interpreted in accordance with the meaning previously given to it. And the reason for that is set out in the last paragraph of the extract, which is as follows: decisions of the court on meanings of phrases in acts of Parliament may come out in the course of time to give them the quality of terms which Parliament may well be assumed to have intended to bring with them and used in the subsequent legislation. So if we're looking at parliamentary assumptions and contexts, we say that they are different. And your Lordship was entirely right in suggesting that there was an observation made by Lady Simler in Mercer, and it's paragraph 108. The general presumption, the same words used in different sections of the same statute have the same meaning, can be rebutted where it is appropriate to do so. So the rule is not an inflexible one. We say, as effectively noted by Lady Simler in the passage I've just taken you to, and is apparent from the extract at page 942 of the bundle to which I've just taken you to. And we say the language and context are entirely different when one compares section 146 with, of the 1992 Act with section 3 of the 1999 Act. The first point to make is that the context in which activities is referred to in section 146 has with it the reference to appropriate time. And the significance of that was again acknowledged by Lady Simler in Mercer at paragraph 45. Page 733 behind tab 30. So the analysis of Drew is supported by the requirement in section 146 that the activity must be carried out at an appropriate time. And the conclusion that Lady Simler draws from the inclusion of those words is in the last part of that paragraph. The intention is plainly to limit the protection to activities which are not inconsistent with the performance by workers of primary duties owed to their employer. So the context in which reference is made to trade union activities in section 146 sits alongside the phrase appropriate time, which is designed to ensure that it excludes those matters to which Lady Simler has referred in the last few words on paragraph 45 of her judgment. The second point to make is that the language, when one compares section 3 and section 146, is subtly but nevertheless significantly different. And this, I'm afraid, involves a compare and contrast exercise between the wording of section 146 and the wording of section 3, which means that it's helpful to have them both open at the same time. It's page 165 is section 3, and section 146.
It's page 25.
Page 25, thank you, lady.
I got the 1999 Act, section 3, page 127.
You're quite right. Yes, apologies, I was looking at the regulations, not the Act. are sometimes advantages to using paper bundles, as I see Mr. Stillett struggling to flag up 2 pages at the same time on his small computer screen. But anyway, I'm sure he'll manage. Yeah, so we look at the difference between, and these submissions are designed to make good the point that you are not required to slavishly follow the conclusions that one draws about the scope of 146 based on the decision in Mercer. So immediately one sees the context is defined in part by the opening words of the relevant subsections. So although we focused on section 3.1a and section 146.1b, part of the context is provided by the introductory words that bring you into those sections. So section 146 is aimed at creating a right not to be subjected to a detriment. So a worker has the right not to be subjected to a detriment as an individual by any act or deliberate failure to act for the sole or main purpose of preventing him from taking part in activities. So contrast that with section 3.1, introductory words. The Secretary of State may make regulations prohibiting the compilation of a list which. So quite apparent that they are doing different things. Section 3 is simply giving the Secretary of State the power to make appropriate regulations based on the underlying mischief. Section 146 is about creating a freestanding individual right not to be subjected to a detriment for having taken part in the activities. So the context is wholly different as between section 3 and section 146. The next point to make is that when one drills down and compares the wording of section 146.1b, so we've looked at the introductory wording in 146.1, we then look at 146.1b and contrast it with section 3.1a, it's almost entirely different. Section 3.1a refers to a list which contains details of members of trade unions or persons who have taken part in activities of trade unions, and 146.1b preventing or deterring him from taking part in the activities of an independent trade union at an appropriate time. And when you compare the language between the two sections, the only words that are in common as between the two sections are part in the activities of trade. The differences are significant. As I indicated a few moments ago, section 146 is aimed at giving a remedy when somebody is subjected to a detriment. Section 3 is aimed at the compilation of a list compiled with a view to being used for the purposes of discrimination. And then at 146, you will see, and this is why I took you to it when we went through the guidance earlier on, you will see that at 146, that the word independent appears. Whereas in the blacklisting regulations, independent does not appear. And we saw that the consultation debate was going on. Those who represented independent trade unions, for reasons that I'm not quite sure of, wanted the inclusion of independent. Parliament intended by the passage of section 3 to create a wider category of people who would be potentially protected once the regulations were brought into force. So a category of people who are intended to be in scope under section 3, who sit outside the scope of protection in section 146. And just for your note again, the relevant part of the consultation process is is 324, paragraph 324 on page 893 of the authorities bundle. The other difference that I want to focus on is blacklists refer to activities of trade unions, plural, whereas section 146 refers to activities of a union. And again, that's an indication that the vice was seen as extending to activity that might take place across a number of unions over a number of years, in respect of which you may be involved in industrial action.
Well, is that much of a point, really?
Sorry?
Is that much of a point?
If I had to rank my points in terms of which were the best ones, it would come slightly low down the batting order. But that's not to say it's not relevant in helping one understand the context of the legislations. Because if the underlying mischief is to address union activity over a period of years, that may involve a number of trade unions, and indicates that the scope of Section 3 and the prohibition, once the regulations were in place, was always intended to go beyond the narrow confines of that which we see in Section 146. And those are my submissions on ground 1.
Right.
Ground 2, you are downhill skiing, to use that analogy. Because once you get to the stage of saying industrial action is included within the scope of the regulations, there is nothing to indicate that that is confined to participation in action which is not actionable under Section 219. And the short points that one can make in relation to that are, there is nothing in the Act or the regulations to indicate that limitation on the scope of industrial action. That construction would be inconsistent with the debate that one sees in the consultation documents, which, as we've seen before, goes the other way. It's not talking about types of union official action that should be included. And perhaps strongest point on this, not to diminish the significance of the previous 2 points that I've just made, is that at the same time that Section 3 was passed, the government passed Section 238A, which is the protection against dismissal during the protected period. And it did so by express reference to Section 219. And so had it been Parliament's intention that industrial action was included only to the limits defined by immunity from suit under Section 219, given that it did exactly that in relation to the new Section 238A, it would inevitably have included a similar prescription in relation to Section 3.
Let me just look at 238A.
Well,
It's automatic unfair dismissal.
yeah.
Protect.
Yeah, there's something to be said for looking at it in its original statutory context, which of course is Schedule 5 to the 1999 Act, because that reinforces the point that in the same piece of legislation, the government introduced a new right under Section 238A, which was
Yes.
prescribed by reference to Section 219 of 1992 Act, but did not include any such prescription in relation to the definition of union activities for the purposes of Section 3. The next point that I wanted to make, just to reinforce that, is that if Mr. Gott is right, it creates almost insurmountable problems for a tribunal wrestling with a blacklisting claim for these reasons. Firstly, the relevant industrial action may have taken place many years before, Secondly, you may only get on the blacklist many years after that. Thirdly, you may not be subjected to a detriment until many years after that. Fourthly, you may not learn until many years later that the reason for your detriment was that you'd been put on a blacklist. Fifthly, there may be some time until the tribunal is then faced with addressing the question of whether or not the original action was within section 219. And sixthly, it may be on Mr. Gott, it would on Mr. Gott's construction, potentially be wrestling with that question in the context of an entirely different employer from that which is in the dock for the purposes of blacklisting regulations. So taking construction workers as an example, you may have a claim against McAlpines, which is based on industrial action that took place when you used to work for Costains, many years before that. And is it really a workable construction of the legislation to say, well, yes, of course, despite the absence of any wording to this effect, the tribunal intended that in the context of your McAlpine claim, it would be a necessary requirement of liability being established that the employee, interesting question as to where the burden lies, but let's assume it lies with the employee. But let me put it neutrally, it would be necessary for the tribunal to be satisfied that the action many years before at Costains either was or was not within the scope of the protection provided by section 219. So, long-winded way of saying that Mr. Gott's submission produces a wholly unworkable scheme in the context of employment tribunals and blacklisting claims.
How common are blacklisting claims?
They're not that common. Yeah, they're not that common. Sometimes you have what you might call sleeper legislation. Until the Coastal litigation on section 145B, that sat virtually unnoticed by potential claimants for a long period of time, and now section 145B claims are very common. The other reason, so it may be that people haven't really recognised their rights, but the other reason why they may be few and far between is, of course, that problem of unearthing the existence and use of a blacklist.
Well, I understand that, because in this case, if this was a blacklist, then it was delivered gift wrapped, in a sense.
Well, even in this case, my lord, we had to proceed on the basis of a bit of a stab in the dark, because if you look at our original ET1, what we asserted was not you did produce a list. We said you must have produced a list.
Yes.
So even then, and the initial response, and I took you to it when I interrupted Mr. Gott in his opening yesterday. The initial response of Ryanair was to say no, we didn't. But things moved on as a result of further and better particulars in disclosure and additional witness statements provided by Ryanair, which we can now proceed on the basis that the list wasn't.
Just remind me, I mean, I've lost focus, but there aren't any cases about it, are there?
About blacklisting?
Yes. I mean, we've got a lot of authorities, and this is a blacklisting appeal. I mean, when you say they're not particularly common, have they surfaced in any?
Yes. So, Mr. Brittenden reminds me there's a case called Miller and Interserve, which deals with things like whether a list kept in your head is a prohibited list.
That's a decision of what?
That's an EAT decision. Yes, it's Mr. Justice Underhill in the EAT, and it's in the authorities bundle at page 452. But I don't think it sheds any light on the particular issue that we're dealing with today. And so that's my ground two. Can I, and I really am taking this at a pace now, I'm going to rush through the Human Rights Act points, not least because we say you never actually get there, which is perhaps the strongest reason for not worrying about human rights arguments. But we can put it very briefly as follows. Whilst it may be the case that the European Court has not addressed blacklisting head-on, it has nevertheless recognised that industrial action and the right to strike is an important aspect of freedom of association. See Ognebenko, paragraph 70. Mercer.
Have you got these references in your skeleton?
Yeah, well, I'm happy to deal with it that way, my Lord. I'm conscious of the fact that the sands of time are running slightly against me, so I'm happy to leave that.
If
I'm not going to add anything to.
If it's down there.
Yeah. Well, shall I leave it at that then and move on to ground 3?
Yes.
So ground 3 only arises in the event that you construe the regulations so as to be limited to protected action. And the question then arises whether, in the light of the challenge to the protection under section 219 that was mounted in the High Court, Ryanair would be guilty of an abuse of process if they sought to run a similar defence. I'll take the point quite quickly. And just to make good these points, I will need to take you to a couple of documents. If you look at the supplementary bundle at page 51, you will see that the declaration that is sought is first and foremost by reference to Mr. Morais and his colleagues. And that is plainly relevant, not least in the light of the observation made by my Lord Justice Jackson yesterday about the proximity test. Because what an industrial action injunction is aimed at is making sure that the members come into work. It's not some ethereal remedy sought against a union. It's a remedy that is sought with the order that the trade union communicates to its members that the action is unlawful, so as to get members not to take strike action. And you can see that in the terms of the injunction that is sought. If you turn over a couple of pages to page 53 of the supplementary bundle, you will see that the injunction is sought not to induce members to take industrial action, and indeed requires the union under paragraph 2 of the injunction sought to notify all its members that they should not take industrial action. And it's, of course, designed to take the sting out of the leverage that the union seeks to exert by calling its members out. The effect, of course, of Ryanair failing in its industrial action application, abandoning its case in the High Court that there was a breach of section 219, means that Mr. Morais can take strike action on the face of it in the belief that he has the protection of Section 238A. And I'm going to try and run this as a conventional sort of estoppel by representation point, because it's plainly not that. But when he takes strike action, he does so in the firm belief that what he's doing is protected industrial action, which protects him from dismissal under Section 238A. And the reason why that's important is particularly when one considers the privies point in this case. Because what it means in this case is that if Mr. Gott had said to Mrs. Justice Lambert, well, can we have a speedy trial on this because the industrial action is going to carry on for some while. And she'd said yes, and they'd had that speedy trial, and he'd lost. On his case, because there is insufficient commonality of interest or privity as between the union and his members, they could still dismiss Mr. Morais and say and raise the protected action point in the Employment Tribunal and say, well, no, there's not sufficient commonality of interest in this question of whether or not the action is unlawful. Not sufficient commonality of interest as between the union and its members in circumstances in which he has sought an injunction aimed at preventing those members from taking strike action. Strike action has been taken, and it cannot be right, we say, as a matter of common sense, that if he'd lost his speedy trial and Mr. Morais had been dismissed in circumstances which prima facie breached Section 238A, he was entitled to come along to the tribunal and run exactly the same case in the Employment Tribunal in relation to which he'd been defeated in the High Court. That would be, we say, an abuse. Possibly a cause of action estoppel. But in either case, what that point serves to demonstrate is the commonality of interest as between the union and its members. And Mr. Gott takes the point about the specific legal status of a trade union by reference to the definition contained within the 1992 Act. But we say that that is to ignore what a trade union is. A trade union only exists for the purposes of defending and pursuing the interests of the individual members. It is the mechanism by which individual members negotiate changes to their terms and conditions. BALPA was the recognised trade union in this case. Mr. Morais couldn't go and knock on the door of Mr. O'Leary at Ryanair and say, can I have an extra 10%, please? The only way that he could get an increase in his pay was to use his trade union as the recognised body for negotiating terms and conditions to pursue that debate on his behalf. And that is the true relationship between a member and the union, and demonstrates that there is, I'm going to use the word alter ego because I don't need to use that language, but there is sufficient proximity of interest between them that it would indeed be unjust for Mr. Gott, having thrown his hand in the High Court, to come along a number of years later and run the same points that Mrs. Justice Lambert was somewhat dismissive of in his application.
It doesn't make any difference, does it, whether it's a few years later or a few days
No,
later?
it doesn't. The point is, I agree, but it's a slightly aggravating feature that it would be so long after. But the importance is that on his case, they are to be treated as two entirely different entities, with the effect that you can run before the tribunal that which has been determined on an interlocutory basis followed by discontinuance, or which could have been determined on a speedy trial basis. Doesn't make any difference on his analysis.
Is there any recorded example of an employer doing this? I mean, back in the day, I was involved in lots of interlocutory injunction applications to stop strikes, some granted, some not. But I can't recall any example of application for injunction refused, claim discontinued, then same issue being raised either with the employer as claimant or with the employer as defendant in similar proceedings.
I think it depends what you mean by similar proceedings. If you mean proceedings in the Employment Tribunal, well, given that 238 only came in 2009, it may be that, I'm pretty sure before your lordship's time.
Well, way after my time. But,
yeah.
But it leave me out of it, as it were. Has this been done before?
No, I'm not aware. I'm not aware of it. No. I mean, Mr. Gott's right in one sense that even without the presence of a speedy trial, the assumption of all parties, once the application is failed, is that Section 219 defences in respect of the particular industrial action are dead and buried. That's what, and although it's decided, and Mrs. Justice Lambert uses the language of Section 219, likelihood of the defendant succeeding, if you actually look at her judgment, it dismisses Mr. Gott's technical points as having no merit whatsoever. So although, of course, she uses the correct statutory language, if you just look at the 4 points that he raised and are dealt with in her judgment, and I can take you to them, but I'll just flag them up for now. He ran 4 points. He didn't lose those points on the basis, well, yeah, these are arguable, but I think the defendant's going to win. He lost them because they were technical points devoid of merit. Tempted to say the same about some of the points he's raised today, but that would be unfair, so I'm not going to do that. So we say it is Henderson and Henderson abuse. We rely on the judgment in particular of Lord Bingham in Johnson and Gore Wood, references at A341, the authorities bundle, and the sufficient degree of identification point that he makes at paragraph 32 C2H on page 342 of the bundle. And we say it's quite right that abuse was identified in this case. Claimants sought to improve their terms and conditions, sought to do so in a way that was expected and agreed by Ryanair. BALPA was the recognised trade union. See page 215 of the bundle, the ET1, where we set out that they were the recognised trade union. That was admitted in the ET3. Collective bargaining broke down, members voted. The action would not be lawful unless members had voted in that ballot, so they are a necessary participant in the balloting process. BALPA then called members to take action. Ryanair tried and failed to stop them doing so. They shouldn't be allowed, as a matter of procedure, to run those points again in the Employment Tribunal.
We've been considering this, it seems to me, rightly under the umbrella of Henderson, but it's actually quite a novel subspecies of Henderson. But Henderson is typically could or should have brought a point forward before, and it's too late to bring it forward now. This is a variant whereby the point was brought forward.
Yes.
And was then consciously abandoned.
Well, the fact, I think we get it from Johnson and Gore Wood, which is that the fact that a matter has been compromised rather than dealt with by way of a judgment doesn't change the position as far as the applicability of abusive process is concerned. There's one passage that may assist on this point. Yeah, the absence of a final judgment dealt with by Lord Bingham in Johnson and Gore Wood, page 32 of the Authorities Bundle, letter H, and from memory, page 32 of the Authorities Bundle, letter H, and just before no, it can't be 32. That's wrong.
300.
Page 32 of the judgment, I suspect.
342.
342. Thank you.
Thank you.
Just one passage that may help. Yes, there's an important passage at 341 where Lord Bingham talks about Henderson's use of process, and a particularly important sentence at 341H, where he says one cannot comprehensively list all forms of abuse, so that one cannot formulate a hard and fast rule to determine when on the facts abuse will be found, but then goes on to say whatever legitimacy of its defence, the rule has a valuable part in play in the protecting the interests of justice. So that's we say, an important passage from that case. Gone slightly over my time, for which apologies, but I hope I haven't dwelt unnecessarily on points in the case, but obviously if there are any other matters that I haven't covered, I would be happy to do so if your lordships or your ladyship have any additional questions. Thank you.
Thank you. Mr. Brittenden? Right, Mr. Stillitz.
Thank you, my lords, my lady. The Secretary of State, as you'll appreciate, doesn't make submissions on the last point that my friend Mr. Carr's been dealing with, nor does it make submissions, nor does the Secretary of State make submissions on the specific facts of this case. In regard to the issues on the appeal, however, we do make the following three submissions. First, the phrase activities of trade unions within the blacklisting regulations is plainly apt to include industrial action. Secondly, that phrase applies to all official industrial action in the sense of being action authorised or endorsed by the union, whether or not it also enjoys the protection from suit in tort provided for under Part 5 of the 1992 Act. Thirdly, if, contrary to our primary submissions, on ordinary domestic principles of interpretation, Regulation 3 doesn't extend to lists made of those participating in industrial action, we submit that would give rise to a breach of Article 11 of the Convention, and in those circumstances, pursuant to Section 3 of the Human Rights Act, Regulation 3 should be interpreted in a convention-compliant way. And I propose to develop those submissions under the following headings. First, I wish to return to the blacklisting regulations and make some general submissions about their structure. Then I will turn to the meaning of the phrase activities of trade unions. Then I'll deal with what types of industrial action we say are caught. And fourthly and finally, I'll deal with Article 11. So with that framework in place, I turn just to the blacklisting regulations in general terms. And as my learned friend Mr. Carr has outlined, those regulations were enacted to provide protection against what Parliament considered to be a particularly pernicious and specific form of anti-union discrimination, namely the organised stigmatisation of certain workers by compiling lists of them, in particular those considered to be troublemakers. Those lists could then be used to exclude or victimise the workers whose names appear on them. And the objectionable nature of blacklisting is compounded by the fact that a worker usually has no way of knowing they are on a list or challenging their inclusion on it. And the impact of being included may be felt unbeknownst to the worker for many years to come and in many different circumstances. That is the mischief at which the regulations are directed. Now, if I could take the court back to the regulations themselves, they begin at page 163 of the bundle. And Regulation 3 at 165 sets out, as it were, the gateway to the application of the regulations. And we note that it's a very particular one, very specific one. At 3.1, subject to Regulation 4, no person shall compile, use, sell or supply a prohibited list. At 3.2, a prohibited list is a list which A, contains details of persons who are or have been members of trade unions or persons who are taking part or have taken part in the activities of trade unions. And then critically B, which we haven't really focused on, is compiled with a view to being used by employers or employment agencies for the purposes of discrimination in relation to recruitment or in relation to the treatment of workers. And discrimination in this context, subsection 3, subregulation 3, means treating a person less favourably than another on grounds of trade union membership or trade union activities. And what we see then is that for the gateway to apply, the list must have been compiled with a view to using it for the purposes of anti-union discrimination. That must be its purpose at the time of compilation. So it's a very specific and very narrow form of discrimination, but a very serious one. And just so that the court is aware, the Employment Rights Bill currently before Parliament, perhaps having taken consultation on that very narrow definition of prohibited list, makes provision for the possibility of a wider protection in this area. And just so that the court has that, that's at page 958 of the bundle. Clause 53 of the bill which seeks to amend section, in due course, assuming it passes, section 3 of the 99th Act, by the introduction of a new subsection 2A. The Secretary of State may make regulations prohibiting the use of lists which contain details of members of trade unions or persons who've taken part in the activities of trade unions for the purposes of discrimination in relation to recruitment or in relation to the treatment of workers. And it would appear that the purpose there is to focus on the use of lists rather than merely on the purpose in compiling the list, which renders it, as currently things stand, a relatively narrow protection. Turning back to the regulations, Regulation 4 is important. If we could go there, please, at page 165. Because that sets out a number of scenarios in which Regulation 3 is not contravened. And the most important one for present purposes is Regulation 4.5 at page 166. The fourth case is where a person compiles, uses, sells or supplies a prohibited list, but the compilation, use, sale or supply of the prohibited list is required or authorised A, under any enactment, B, by any rule of law, or C, by any order of the court. And just to take an example of that, if an employer made a list of those employees it was not going to pay in respect of a strike day because they hadn't attended, that would be authorised by Section 14 of the Employment Rights Act 1996, which specifically permits employers to deduct wages for those who are taking industrial action. That section is in the additional clip of authorities of sections that we have up. If I could just take the court to that. It's a very short additional clip, but so the last page of that clip is section 14 of the Employment Rights Act 1996. Section 13 creates a right not to have wages deducted without authorisation. Subsection 14.5 says Section 13 does not apply to a deduction from a worker's wages made by his employer where the worker has taken part in a strike or other industrial action and the deduction is made by the employer or account of the workers having taken part in that strike or other action. And so if an employer compiled a list for the purposes of Section 14.5, clearly that would fall within the Regulation 4.5 exemption. Moving on through the regulations, Regulation 9 deals with the concept of detriment at page 169.
Sorry, just pausing.
Yes.
I haven't looked at this before. So you could make a list in order to not pay the person, but on your submission you couldn't make a list in order to deprive them of concessionary benefits.
Indeed, my lord, because that would be unlawful victimisation of those who participated in industrial actions. The key point about deduction from wages is it's established common law,
yes.
Miles and Wakefield, under statute, section 14.5, and indeed by Lady Simler in Mercer itself, where she says it's not a detriment.
Right, so if an employer wanted to make a list of the sort that was made in this case and benefit from the subparagraph 5 authorisation to do so, this section 14 would have to be more widely drafted.
If for the purposes of a discretionary benefit, indeed.
Yes.
Yes, that's
Right,
correct.
so if Parliament had wanted to extend it beyond workers' wages and say, and also you don't have to give them things you didn't promise them.
Exactly. It would have to be more widely drafted. And Regulation 9 at page 169 deals with the concept of detriment because the cause of action isn't complete unless there's a detriment. And Regulation 9.1 says a person has a right of complaint to an employment tribunal against B's employer if D or any act of any deliberate failure to act subjects P to a detriment for a reason which relates to a prohibited list. So there must be a detriment. And again, that deals with the wages point because Lady Simler has now held in terms in Mercer that deducting wages is not a detriment. So for that further reason, it wouldn't apply there. Regulation 11 deals with remedy, and I won't repeat points made by Mr. Carr, but a key point about this to note is that these regulations contain a punitive element in the sense that once compensation is awarded, it starts off at a minimum of £5,000, and that's an unusual provision in employment protection law. But in my submission, it reflects the seriousness with which this particular practice is viewed.
It's rather unusual to have a minimum of 5,000, but the tribunal can award zero.
Yes, I would respectfully accept that that is unusual. I suppose it gives a tribunal the opportunity, if there is a wholly inadvertent or de minimis breach, or perhaps the employee didn't suffer any harm, loss, damage, or anything of that sort, just not to go there. But I would be inclined to agree that the logic of having a punitive provision would be that it should be applied irrespective of the consequences, but that's how Parliament has chosen to do it.
Right, so if the employer made a list to say, take X, Y and Z off the Christmas card list, then it might be thought we're wasting our time and we're not going to...
Indeed, that might well be an example where they just find it doesn't meet the threshold where compensation of that size is warranted. Yeah. Then we have Regulation 11, which introduces Section 104F. And I'd like to return to that because in my submission, a false equivalence is drawn between Section 104F, dismissal, and Section 152, relating to trade union activities. And it's important to look at the terms of Section 104F, and we can conveniently look at it here at page 172. An employee who's dismissed shall be regarded for the purposes of this part as unfairly dismissed if the reason, or if more than one, the principal reason for the dismissal relates to a prohibited list, and the employer contravenes Regulation 3 of the 2010 regulations or relies on information supplied by someone who's done that. And so, again, it's a very narrow species of automatic unfair dismissal. First of all, the principal reason or only reason must relate to the prohibited list. And secondly, in addition, the employer who's dismissing must have contravened Regulation 3 and not, for example, fall within any of the exceptions in Regulation 4. It would be quite wrong to suggest that that narrow automatic unfair dismissal protection is coterminous with sections 237 to 238A of the 1992 Act, as is submitted by the appellant. So those are my general remarks about the regulations. I then turn to the first submission. What is the phrase activities of trade unions apt to include? And in this respect, we submit, in summary, that the appellant's argument amounts to a case of the Mercer tail wagging the blacklisting dog, if I can put it like that. They're putting far too much weight on parallel but different arguments in Mercer and seeking to import them wholesale into an entirely different piece of legislation in a way that it's unwarranted, and I'll explain why in a moment. First of all, Mr. Carr's made these points, and so I don't take them at length. The entire premise of this argument is false. The premise of this argument is that the same phrase appears in Section 146 of the 1992 Act and in the Blacklisting Regulations. It does not. In fact, the phrase activities of trade unions appears nowhere in the 1992 Act. Or at least my Westlaw section of the Act indicates that it appears nowhere. I can't claim to have read every section. But the phrase is not the same. And it's not just trivially different, it's importantly different. It's importantly different principally for two reasons. Section 146 protection only applies to independent trade unions. Blacklisting protection applies to all trade unions, including staff associations. So just from that inclusion of the word independent, these are sections which refer to completely different categories of organisation. Secondly, the reference to activities of an independent trade union is a reference to activities at an appropriate time. Those words follow directly on. And that is an absolutely critical difference. And it would be wholly artificial to ignore those words in seeking to suggest that we're talking about exactly the same phrase here. And one must read activities of trade unions in the blacklisting regulations as meaning the same thing as activities of an independent trade union at an appropriate time in the 1992 Act. It's the height of artificiality, and there's no warrant for it. So, for these reasons, the phrase used in Regulation 3.2 is a very different beast from that used in Section 146 of the 1992 Act. And once it's established that the blacklisting regulations are differently worded to the expression used in Section 146, the heavy reliance placed by the appellant on Mercer is unwarranted. Mercer was dealing with a very specific statutory problem. And the problem was, in a nutshell, that Section 146 and Section 152 were obviously sibling provisions, providing protection for those participating in the activities of trade unions, independent trade unions, on the one hand detriments, on the other hand dismissals. So they were clearly intended to mean the same thing. However, there was also within the 1992 Act, sections 237 to 238A, which deals specifically with dismissals for participating in industrial action. Therefore, if the phrase activities of an independent trade union in sections 146 and 152 include industrial action, the Act would be internally inconsistent.
And that goes back to Drew.
That goes back to Drew. But the key point about Drew is the reason that Drew was decided rightly as it was, is that you had, from the inception of this legislation, one set of provisions dealing with trade union activities, and to be contrasted with that, protections relating to strike action. From the very beginning, those were in play. And so one could only make sense of that legislation as a coherent whole by distinguishing between strike action activities of an independent trade union. And interestingly, it was a key part of Lady Simler's analysis that she looked very carefully at the legislative history of these provisions, going right back to the Industrial Relations Act 1971. We see that at paragraph 48 of her judgment, which is in the authorities bundle. Give me tab 30. tab 731, I'm told.
No,
734. But if one looks at paragraph 48, ladies and gentlemen engaged in a very, very detailed analysis of the history of sections 146 and 152. Beginning at paragraph 48, she follows that all the way through to paragraph 59, which is at page 736, where she says the legislative history demonstrates that the predecessor provisions of sections 146 and 152 had a shared source in the 1971 Act and before it in the ILO Convention. The original statutory protections used the term appropriate time. That was the point my Lord Justice Bean made yesterday. In the same way and precisely replicating the wording of the 1971 Act, the only point at which the 1971 Act protections against dismissal and action short of dismissal in respect of trade union activities were not both on the statute book was for a short period between 1974 and 1975, but once reunited in the EPCA, they've remained in the same statute. The legislative history also shows Parliament has consistently chosen to provide for protection for trade union activities at an appropriate time, whether it's only ever given more limited and varied protection for striking employees. That was the rationale for the natural language of section 146 not being followed in Mercer, because it just didn't make sense in that wider statutory framework. None of that troubles us in the blacklisting regulations. A wider definition of activist trade unions causes no problems, nor does section 104F, which is much more limited in its application than sections 237 to 238A. And so Mercer does not assist the appellants at all. And I won't go back to them, but in our submission, if the appellants were right, this would be a very egregious example of legislation not doing what it was plainly intended to do. It couldn't be clearer in the preparatory materials, consultation and so on, that this was intended to apply to trade union to industrial action. And whilst that's not conclusive, it would be very surprising if inadvertently it failed to do what it was clearly envisaged it should. So I come next to the question of what industrial action does the protection apply to? As already noted, the blacklisting regulations provide protection against a particularly serious and specific species.
Sorry, do these submissions map onto ground one and ground two?
So this is ground two.
You've just dealt with
I've dealt with ground one, apologies.
And now we're on ground two.
I should have made that clear. I've dealt with ground one, I now turn to ground two. As I've already indicated, the blacklisting regulations provide protection against a particularly serious form of anti-trade union discrimination. And we make a perhaps trite, but we submit correct point on this, which is to say, where the regulations refer to the activities of trade unions, they should simply be taken to mean what they say. Calling industrial action is par excellence an activity of a trade union, and it remains an activity of a trade union whether it fulfills all the conditions in Part 5 of the 1992 Act for immunity from suit or not. It can only apply to official industrial action for this reason, that unofficial trade union action isn't an act of a trade union.
So your submission is that there shouldn't be any adjective or qualifier before activities of trade unions?
There doesn't, but a wildcat strike, which is not endorsed or authorised by a trade union, can't properly be described as the activities of a trade union, because ex hypothesi, it's not the trade union that's called it. So it's not, we're not making any fine distinctions. We're just saying, look at whether it's a trade union activity. Simple as that. And we do submit that it would be extravagant and unnecessary to seek to incorporate the distinction between protected and official industrial action by implication into the blacklisting regulations when they make no reference whatsoever to that distinction. And the consultation documents were very clear that any official action would be covered. But there's a further practical point, and this is a slightly different point from the abuse of process point that's raised in this case, which is that, as my Lord Justice Bean in particular will be very familiar with, Part 5 of the 1992 Act is quite complicated. I won't take the court back to it, but under Section 219, one has the basic definition of immunity. At that stage, one sometimes has arguments about was the strike called in contemplation or furtherance of a trade dispute. So that's one battleground. Then at Section 219.11, there's a whole range of circumstances in which that protection can be disapplied for excluded action and ballot notices and all the rest of it. And there's more detail than in the remainder of Part 5. So Section 222 excludes strikes which discriminate on trade union grounds as their aim. Section 224 excludes secondary action. Section 225 excludes strikes to impose union recognition rights. And then at Section 226 and following, we have the very complicated balloting provisions, which are very, very exacting. At 226A, we have the complex notice requirements. You need a sampled ballot paper. Section 226B, the need to have a scrutineer appointed. Section 229, very, very detailed specifications as to the contents of the voting paper. Section 230, very, very prescriptive provisions as to the way in which the ballot is conducted. I could go on. The point is that these are very, very complicated provisions which one needs to look very closely at the process to decide if they've been complied with. And it would be, in my submission, very odd indeed if an employment tribunal hearing a blacklisting detriment case could be called upon to examine all of these very complex and difficult questions to see if an action which ex hypothesi hasn't been injuncted by the High Court in fact fulfills all of the requirements for protected industrial action. It would add a massive range of potential issues and potentially huge factual inquiry to what is supposed to be a simple claim for detriment. And then finally, I turn, and this is really in answer to my Lord Justice Peter Jackson's question, this is a point which goes to both, really both grounds 1 and 2, which is the Article 11 point. It was established in Mercer that, in the Supreme Court, that the failure of the United Kingdom to provide any protection against imposing a detriment on those who engage in industrial action gives rise to a breach of Article 11 of the Convention. And if we could quickly look at what Lady Simner said about that, it's paragraph 90, which is at page 746. Sorry, that's not right. Page, yes, that is right, 746. She said, had there been regulations addressing action short of dismissal?
No, legislation.
Sorry, legislation, I apologise. Addressing action short of dismissal, it might have been possible to say that a fair balance had been struck by Parliament, given the wider margin of appreciation to be applied. However, I consider that the failure to provide any legislative protection at all against any sanction short of dismissal for lawful industrial action against those who take it does put the United Kingdom in breach of its positive obligation to secure effective enjoyment of the right to participate in a lawful strike that is protected by Article 11, including as regards the private sector. Indeed, I find it difficult to see how a balance has been struck at all. And she goes on at paragraph 121, which is at page 755. Accordingly, I would make a declaration under Section 4 of the HRA that Section 146 is incompatible with Article 11 insofar as it fails to provide any protection against sanctions short of dismissal intended to deter or penalise trade union members from taking part in lawful strike action organised by their trade union. Now, my learned friend Ms. Claimants said it's not right to characterise that as a lacuna. I mean, that was on a different point. The lacuna point was on whether there should be a declaration of incompatibility. Was there simply a lacuna, or was Section 146 as drafted something that breached the Human Rights Act? That doesn't matter for present purposes. Call it a lacuna, call it a lacking, call it an omission, call it a falling short. There is a gap in UK protection which creates a breach of Article 11. That's what Lady Simler found. And that gap is the absence of protection against sanctions short of dismissal for taking part in industrial action. So that's the gap that's been identified. Now, turning to this case, if the appellants are right, and the blacklisting regulations similarly provide no protection whatsoever against for those who participate in industrial action. If they're right about that, then the Article 11 shaped hole in UK employment protection gets larger. The lacuna is enlarged, the shortcoming is greater, the deficit is larger. And in my submission, if that argument is correct, then the deficiency identified in Mercer is compounded. And just to be clear, and I confess we may not have been as clear as we might have been in our skeleton, just to be clear is exactly how the Secretary of State puts this. We submit that if the appellants are correct in saying that the activities of trade unions do not include industrial action at all, then we positively submit that that would entail Article 11.
Say that again.
Sorry to drown out
No.
our important parties.
Obviously something
Just
very
wait.
unpalatable in what I was
Just
saying.
wait for
But
the storm to pass.
no.
It wasn't anything you said. Okay, try again.
I'm grateful. So
If Ryanair are right,
if Ryanair are right and the blacklisting regulations don't protect those who participate in industrial action at all, then that enlarging of the shortcoming in the protection would amount to a breach of Article 11. It would be enlarging the gap, the Article 11 shaped gap. Where we've hedged our bets somewhat, and it just seems to be, frankly, a matter which probably would need to be determined the other day, is if they're only right to the extent that protected industrial action falls within the blacklisting regulations. In our submission, it's a moot point as to whether that in itself would give rise to a breach of Article 11. And I say that for the following reasons. Lady Simler confined the gap identified in Mercer to protected industrial action. So that case only deals with protected industrial action having no remedy. However, for the reasons that my learned friend Mr. Carr has outlined and I've mentioned at the top of my submissions, blacklisting victimisation is a particularly offensive and serious form of anti-union discrimination. And so in our submission, it is by no means certain that even if Ryanair are wrong on ground 1 but right on ground 2, that would not involve a breach of Article 11. We say we simply don't get there because we don't need to, because they're wrong about ground 1. But if they're right about it, we submit that Section 3 of the Human Rights should be used to read Section 3 of the 99 Act and the Blacklisting Regulations more widely, so as to include industrial action. That plainly can be done under the interpretive obligation under Section 3. Doesn't do violence to the Blacklisting Regulations or anything of that sort. Doesn't go against any grain. Section 104F's a red herring. And so, unlike in Mercer, where there was this problem of internal inconsistency, one can use Section 3 to read down the Blacklisting Regulations.
Are we talking about the regulations and the Act, or the regulations
Well,
only?
in our submission, one would probably need to read down both, because the phrase is the same in both.
Yes, but I mean, I mentioned it yesterday because the point was made. This is very odd. You're seeking to render regulations incompatible.
Yes. Well,
Whereas actually, I mean, aren't the two just hand in glove with each other? The regulations do no more than reflect the wording of the
I would
of the
respect.
statute.
I would respectfully accept that. And so, if it is the case that the phrase "activities of trade unions" in Section 3 of the 1999 Act doesn't include on a conventional domestic interpretation, where the phrase "the activities of trade unions," if it doesn't include on a conventional interpretation industrial action, then Section 3A1 of the Act should be read down to include industrial action, likewise the Blacklisting Regulations. If the appellants are right and activity of trade unions in Section 3 doesn't include industrial action, and they're right that Section 3 can't be used to read it down, then we accept that it would be open to the court to make a declaration of incompatibility on the basis that the scope of the blacklisting regulations will have been constrained by the inadequately narrow terms of the primary legislation.
That would be what, the 1999 Act?
The 1999 Act, yeah. But we can't stress strongly enough that one has to take a number of, we would submit, wrong turnings if one gets to that result.
If one got to the stage of having to read down, and I appreciate your submission is that one never gets that far, but isn't there a problem as to whether you read down to say that the Blacklisting Regulation 3 activities of trade unions includes all, let's call it protected, Section 219 immune industrial action, or only protected Section 219 immune industrial action, or all official industrial
Yes, that is a problem. That's exactly the problem that the Supreme Court had to grapple with in Mercer. And they took a minimalist approach in that,
Yeah.
and so held only that the declaration was that the absence of protection of detrimental activity for participating in protected industrial action gave rise to a breach of Article 11. They didn't go any further than that. And that was because they accepted that the state has a wide margin of appreciation as to how much protection is provided, and it was only because there was none at all they felt it right to make a declaration of incompatibility under Section 4 of the Human Rights Act. So unless... sorry.
Just one point, if I may. Sorry, I just wanted to... it's a very small point, but we heard submissions about nobody rushing to support the EAT in relation to the expression union industrial action. It's at page 131 of the tour bundle. Once one's reached the point where it was accepted that industrial action was within scope, and one was considering under ground 2 whether distinction between official and protected industrial action. This is the context in which the judge was speaking. It may be unnecessary to say union industrial action, but at the moment I'm not seeing what's objectionable about it as simply a way of encapsulating what he says at the very end. There's no doubt this strike was about a strike. I mean, he appears to be using it as not as a term of art, but simply as a way of telling you what he's meaning when at various points earlier in the judgment he's referring to union-backed action.
Yes, and in fact, on one reading of His Honour Judge Albach, union industrial action in practice is coterminous with official industrial action because
well, it is, but it's also, I mean, the term that we have to construe is activities of trade unions. Yeah. And once one accepts that strikes are included in activities of trade unions, then it's simply putting the word, instead of activities of trade unions, it's just putting the words backwards.
Yes.
As a label. I just wanted to know whether you had any submission to make about that as...
Well, we would accept, as a matter of logic, that industrial action called or endorsed by a trade union will fall within the phrase activities of trade unions, whereas action which is not called or endorsed by a union won't, because it's simply not an activity of a trade union at all. Whether one attaches the label official, which conveniently sits in Section 20 of the 92 Act, to make that distinction, or whether simply one says any industrial action which is an activity of a trade union, we would accept either approach was appropriate.
Thank you. That's all I wanted to ask.
I'm grateful. Unless there's anything else, those are submissions of the Secretary of State.
Thank you very much. Ms. Slarks? Right, Mr. Gott.
May it please the Court. I think I have only 5 points. I can deal with them in, let's see, 10 minutes or less. My Lord, there's a matter which Mr. Khan didn't address, which is Section 104F of the Employment Relations Act, which was introduced by Regulation 12 of the Blacklisting Regulations, which is automatic unfair dismissal for a reason which relates to a prohibited list. Mr. Carr left that unmentioned. Mr. Stilts
suggested that it was a narrow issue and not a matter of concern or problem. My Lord, it isn't. As I submitted yesterday, it is the equivalent for the purposes of sections 238 to 238A. It's the equivalent of section 15 of what section 152 was in Mercer. On the one hand, you have a dismissal for a prohibited list, and in any piece of industrial action, there will always be, my Lord, lists. So the allegation can be made in the same way as the allegation was made in this case by Captain Morais and his colleagues. Well, you must have had a list, and therefore this is a detriment, or in the case of section 104F, a dismissal by reference to prohibited list for my participation in industrial action, which is the activity of a trade union. And indeed, we see, nobody's gone to it, in Miller and Interservice, page 452 of the bundle, that lists can be mental lists. That was held by the Employment Tribunal. My Lord Justice Underhill dodged a definitive conclusion on that issue for the purposes of the EAT. And so we come back, my Lord, to the judgment of Lady Simler at page 732 to 733 of the authorities bundle, and her confirmation of Drew.
Yes.
It would be quite impossible for the same person to fall under both sections at the same time, and that is the difficulty, which the impossibility in my submission, which arises from section 104F. Now, I acknowledge, my Lord, that that there was a detailed examination of section 146 on the one hand and section 152 on the other hand, and the statutory development. But section 104F was brought in by Regulation 12 of the Blacklisting Regulations, and the Blacklisting Regulations themselves were enabled by the 1999 Act, which itself also brought in section 238A, the provision on protected industrial action, within Part 5 of the 1992 Act. And it is clear under those circumstances that they have to be read consistently, and they have to be read in a manner in which they can operate consistently, and that is, in my submission, impossible if activities of trade unions is interpreted as including industrial action. On my learned friend Mr. Carr's point, section
this is a separate point, is it? Or?
Sorry, yes, his number. Yes.
1 to 2.
I'm on to 2, my lord.
Right, 2.
We're not on my learned friend Mr. Carr's point on rules of statutory interpretation. We're not just dealing with the rule of statutory interpretation. We are dealing with section 3.6, page 127 of the bundle, we're dealing with section 3.6 of the 1999 Act. Subject to subsection 5, expressions used in this section and in the Trade Union Labour Relations Consolidation Act shall have the same meaning as in that Act.
Okay. The effect of that is that you pretend that section 3 of the 1999 Act is somewhere tacked on to the 1992 Act, so you're reading them as though they're a single statute.
My lord, yes. I hadn't thought of it in that terms before, but yes, that would.
But it's still subject to Lady Simler's observation that although generally if the same phrase is used in different sections of an Act of Parliament, it means the same. Words mean the same.
Well, yes, but my lord, we mustn't, and I'm trying not to repeat myself here, we mustn't forget in this context that the 1999 Act is itself making very considerable amendments to the 1992 Act, including introducing the provisions on this in respect of dismissal for protected industrial action.
Right, that was point 2.
Point 3 is at an appropriate time. Now, a great deal of material in respect of the regulations was examined in respect of at an appropriate time. There is, but that was, but the regulations are only enabled by the Act. And my lord, you've been taken to no material explaining why at an appropriate time does not appear in the Act. There is background material which we have put forward, which I would ask you to look at in deliberations, which is the Fairness at Work paper and the explanatory notes to the 1999 Act, but none of those deal with the issue. At an appropriate time was thrown up during the consideration of the regulations by the department. And there are, in respect of this, if the absence of at an appropriate time is to have, is to give the words in section 3.1 a different meaning from those interpreted by Lady Simler, either Parliament intended through this first piece of employment legislation enacted by the Blair administration to make a series of coherent reforms to the law on trade union activities and industrial action, which is our position, or Parliament was intending, through silence, to ride a coach and horses to the new section 238A, which it was introducing in the very same piece of legislation. In our submission, in order to make coherence of the 1999 Act as the enabling legislation for the regulations, only the first of those submissions can be correct.
So is your point then that if we were to construe the regulations in the way that we're invited to do by the other parties, then they would be ultra vires?
My point is that you cannot construe that you should construe the Act if you and only the Act.
Yes, so I've understood that you say all this stuff that we were shown was to do with the regulations and not to do with the original enabling Act. So are you still with me?
I'm still with you, and I'm told by my very learned junior that the answer to your Lordship's question is yes.
All right, thank you.
Third point, and this is simply a point I raised by clarification in respect of comments made by my Lord Jackson yesterday. The truth of the matter is that this case was never what the blacklisting regulations were designed to deal with. It was never the blacklisting regulations, and this comes from some of the consultation and formula and guidance material we saw yesterday, were to deal with a much greater problem, which was the circulation of lists, the production of lists, and the genuine blacklisting of trade union members in respect of opportunities for employment or engagement. And you see that really in the simplest form. Your Lordship described this as a case where the list came gift wrapped. The issue with blacklisting, and you see this word repeated consistently through the regulation, through the consultation materials, is that it's a covert activity. But here, my clients wrote to the claimants, warning them, and wrote to the claimants telling them that as they had not listened to the warning, they were going to have the discretionary travel privileges removed. And the response of the claimants is, well, you must have done that by some sort of list. And in any large organisation, administratively, that's almost inevitably going to be the case. One last point. It was being suggested yesterday that on the interpretation that my client is putting forward of activities of trade unions, the list drawn up of my client's employees who took industrial action could be freely distributed. That simply isn't correct. One can't look at the blacklisting regulations in isolation. Trade union membership is a form of special and protected data under Article 9 of the GDPR, as it was in the preceding Data Protection Act. So it would be a serious breach of GDPR for my client, not that it has any intention of doing so, to, as it were, hoke this list around the market or show it to anyone else. And unless I can assist you further.
My Lord, I just want to reply to the 2 points about, or what Mr. Stillett says about the human rights aspect of the claim. And I wonder if in doing that I could just have the Court's indulgence to respond to the point made by Lord Justice Peter Jackson about whether this would mean the regulations were ultra vires.
Yes.
My Lord, the reason why I said the answer to that is yes. And the point is that if you have two possible interpretations of regulation, one of which is within the scope of the enabling statute, and one of which is outside it, then the court must always prefer the version that is intra vires.
Yes.
Basic principle of statutory construction. So that, again, is why we say, a further reason why we say, then of course, the version of the Regulation 3.2a, the interpretation of Regulation 3.2a that should be adopted, is a version that makes those regulations intra vires and within the scope of Section 3.
Your interpretation, excluding any industrial action.
Yes.
Of any sort or description.
Yes.
That's intra vires, and anything else is ultra vires.
Yes.
Right.
My Lord, on the human rights points, Mr. Carr added nothing to what was in his skeleton argument. He didn't engage with any of the points I made yesterday at all, so I have nothing to add to that. In terms of what Mr. Stillett says, he contends that under Ground 1, that the interpretation we advance of the Blacklisting Regulations enlarges the gap that the Supreme Court found existed in Mercer. He's also, on the other hand, sought to construe the blacklist, or sought to persuade the court that the Blacklisting Regulations are a very narrow, very specific category of harm. So any extension of the gap would inevitably be very small. But my key point is that this is not a case, this has never been a case, about gaps or lacuna in the legislation. We've seen that in Mercer. It's the same situation here. One has to find a very specific provision that in and of itself breaches Article 11. We saw the specific provision in Section 146 and why the Supreme Court in Mercer says that breaches Article 11, because it fails to confer protection from detriment and there's a complete gap, there's a complete absence of that protection. That's because, as I said yesterday, the Strasbourg Court is concerned with detriment. Unless one can show that there is a principle that that requires contracting states to include that protection from blacklisting as opposed to detriment, then any argument about enlarging gaps or breaches of Article 11 must simply fail. And as I said yesterday, there is no case, there is no principle upon which this court could make that finding. On his response on Ground 2, obviously I understand Mr. Stillett is in a difficult position. He wants to advance an argument, but it would be contrary to everything the Secretary of State has argued over the last few decades. And he tries to continue hedging his bets in saying it is by no means certain there would be a breach of Article 11 if our interpretation on Ground 2 is correct. And that doesn't address the popular point at all. He's not even articulating a positive case that it does breach Article 11, let alone explaining to the court why that would be the case. So it doesn't address popular, and it doesn't address the multiple cases I showed the court yesterday, where both the Strasbourg Court and the Court of Appeal in this country have found that it is not a breach of Article 11 to limit protection to protected industrial action. Finally, on Section 3, Mr. Stillett asserts the Mercer problems don't arise. We say they obviously do. There is a clear and obvious overlap between Section 104F and 238 and 238A. Mr. Stillett doesn't seek to say that doesn't exist. It does obviously exist. And we repeat the point made about the internal coherence of the 1999 Act, which again Mr. Stillett didn't address, in that you have Section 3 and you have Section 16, which is what introduced Section 238A. My Lord, unless the Court has any further questions, those are our submissions.
Yes. Thank you all very much. We shall, of course, do sit down, Mr. Clement. We shall, of course, reserve judgment. You've given us much to think about. We will send out, almost certainly in the new year rather than in the remaining days of this term, a draft judgment, as counsel well know, but I have to say it in every case. Two things about the draft judgment. One is it's not for re-arguing, only for pointing out typos and factual corrections. And secondly, it's confidential to the parties and their legal advisors, and anyone else who needs to know until it's finally handed down and placed on the National Archive. But you know all that. Thank you all very much for your assistance in this interesting case.